Good morning. Thank you for coming to this event board meeting. We're going to open it first of all by conflict. This is an echo chamber in here. So be careful how you talk into the mic, slow down into the mic, and hear the echo. So we're going to open this also with the security instructions from our staff. Thank you.
I please ask to use the doors behind you guys for you of those in front of you. And then on the right and on the left, there are 2 exit doors. Go ahead and take those exit doors all the way down. Any questions?
Thank you. Thanks. Well, good morning. Thank you for joining us for this Dental Board of California meeting.
Today is Thursday, 15th, 2025. This board meeting is being held in person. This is an official business meeting of the Dental Board of California. The board
Welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking an action on any agenda item.
Depending on the number of testify on a particular agenda item, a total time limit may be imposed. We ask that all speakers please stay on topic and not repeat testimony already provided. If you agree with testimony already provided, please just state your name and that you are in support of any comments previously provided. If a time limit is determined to be necessary, please keep your comments within that time limit. I would like to call the meeting to order and ask the board secretary to please call the roll.
Good morning, Dr. Ledeen, Board Secretary. I will call the roll. Chan?
Chan, aye.
Chan, aye. Cheng?
Chang, aye.
Cheng, aye. David?
David, aye.
David, aye. Felsenfeld?
Felsenfeld here.
Felsenfeld here. Borge?
Forge here.
Borge here. Ledeen here. Medina?
Medina here.
Medina here. Olage?
Malagi here.
Olage here. Thakur absent. And you?
You here.
You here? We have a quorum.
Thank you. We're going to go on to agenda item 20, the board president's report on closed session items. Let's see. So the board voted to reject a proposed decision and remand it back to the administrative law judge. Are there any, first of all, are there any board comments? None. Is there any public comment? Seeing none, thank you. We're going to move on to agenda item 21E, no, A. Legislative proposal to amend Business and Professions Code, BPC, section 1724A to remove dentist licensure fee for repealed portfolio pathway. We're on page 172 to 176. I'm going to ask Mr. Brant Nelson, legislative and regulatory specialist to present this agenda item. Good morning, Brent.
Good morning, Mr. Board President. Prior to January 1st, 2025, a dentist license applicant could utilize the portfolio examination under Business and Professions Code Section 1632, Subdivision C1 as a pathway for dentist licensure. As of January 1st, 2025, the Board of California Sunset Bill amended BPC Section 1632 to strike Subdivision C1A and B, thereby eliminating the portfolio examination pathway. Subdivision C was restructured so that the clinical and written examinations administered by the Western Regional Examining Board and American Dental Board of Examiners, previously listed under Subdivision C2A and B, were renumbered as Subdivision C1 and 2. So what all that gobbledygook means is we are fixing and updating the language. So this is just some Sunset Bill cleanup where we're getting rid of the language that's no longer needed for the portfolio examination pathway for dentist licensure. The action requested is that option 1, move to approve for submission to the California State Legislature legislative proposal to amend Business and Professions Code Section 1724 Subdivision A to remove the dentist licensure fee for the repealed portfolio pathway. Thank you.
Thank you. Is there any board member discussion? Seeing none, we're going to have a motion before us. Anyone want to move this?
I'll make a motion for option one.
You may have to read.
Move to approve for submission to the California State Legislature, the legislative proposal to amend Business and Profession Code Section 1724, Subdivision A, to remove the dentist licensure fee for the repealed portfolio pathway.
Second the motion. Who did we get? Mr. David? Okay. Mr. David, second. Loren did the motion. Any comments, public comments? Seeing none? Madam Secretary, please take the roll.
Board Secretary, I will take the roll on the motion, option one, which move to approve for submission to the California State Legislature, the legislative proposal to amend Business and Profession Code Section 1724, Subdivision A, to remove the dentist licensure fee for the repealed portfolio pathway. Chan.
Chan, aye.
Chan, I. Cheng.
Chang, aye.
Cheng, I. David.
David, aye.
David, I. Felsenfeld.
Felsenfeld, yes.
Felsenfeld, I. Forge.
Forge, aye.
Forge, I. Larin, I. Medina.
Aye.
Medina, I. Olage.
Olagi, aye.
Olage, I. Thakur, absent. You?
You, aye.
You, I. Motion passes.
Well, thank you. Well, that was a monumental move in our history. Let's move on to agenda item 21B, legislative proposal to add BPC section 1778 relating to the board approval of dental assistant educational programs and courses. We're on page 177 to 188 in the meeting materials. I'm going to ask Tina Valerie, good morning, Tina, Chief of License and Program Compliance and Dental Assisting, to present the agenda item.
Thank you, Board President. We presented this agenda item to the Dental Assisting Council yesterday and wanted to bring it to your attention as well. We wanted to highlight the need to change the dental assistant educational program and course review and approval process to an accrediting body that regularly reviews educational programs. It has been about 15 years since the last revisions to the educational regulations were made, and as we all know, there have been significant advances in the dental field and with the electronic delivery of education since COVID. Board staff have struggled to review initial and renewal applications and to perform site visits to ensure each educational program and course meets the minimum regulatory requirements. As mentioned in a previous agenda item, well, yesterday we mentioned it. I'll go over it soon, sorry. We have been conducting standard and complaint-driven reevaluations of programs and courses and have found major compliance issues with the majority. The issues include such things as failing to provide the minimum required number of hours in clinical instruction. Regulation requires a minimum of 265 hours, and what we have seen are programs only requiring as low as 98 hours, 170 hours, 180 hours, and 240 hours of clinical instruction. Program directors are failing to maintain accurate and complete individual student records to demonstrate successful completion of all components of the program or course. For modular or open entry programs, a lack of documentation that students receive basic instruction in infection control and basic chairside skills prior to other program content and activities involving patients, or that they are sequenced appropriately. There are often missing areas of instruction, missing standards of performance on evaluation forms, performance evaluations not being used at all, issues with sterilizing armamentarium, issues with proper usage of extramural facilities. There is often no planned or supervised clinical instruction by the program or course faculty. We are seeing that most course providers enroll students, cover the didactic instruction via electronic media, and then send the students with a homework packet back to their employer dentist to complete the clinical instruction portion of the course. The student then returns the completed homework packet and are then provided their certificates. There is a lack of documentation of compliance with the required instructor-student ratios, a lack of documentation that students are provided with specific performance objectives and standards of performance for laboratory and clinical experiences. Some of the evaluation forms merely say done or not done. The board is often not updated when programs and courses make changes to their curriculum, faculty, locations, and closures. These are just some of the issues we are finding in the reevaluations we have recently conducted. I also want to point out that in the last year, we have conducted 4 RDA program site visits, and we have 92 that we are responsible for reevaluating every 7 years. And this is just RDA programs. We have over 903 other program and course providers, which require the same oversight. Additionally, we think it is important to point out that of the 21 reevaluations that the board has completed in the last year, 12 have had their approval withdrawn. 3 have been granted continued approval, and 6 have reported that they have closed. To be even more specific, of the 4 RDA programs that were reevaluated, all have had their approval withdrawn. Another issue that has been discovered after conducting a fiscal analysis and desk audit in relation to Assembly Bill 873 for the interim therapeutic restoration and radiographic decision-making, radiation safety, and infection control courses is that the $300 fee that is charged by the board does not cover staff costs, and the application fees should be increased significantly to cover those staff costs. To resolve all these issues I mentioned, we are proposing to move the approval of dental assisting educational program and courses, education accrediting, and approval agencies. With the discussion with the DAC, we have proposed to take this back to the working group and to have stakeholder meetings and discuss this further, and that's what we agreed upon. So this is really just informational at this point. And I'd be happy to answer any questions you may have.
Thank you. This has been a monumental accumulation of data and what the marketplace looks like. So please thank the staff for accumulating and bringing it to us today. We have a element before us. Is there any board member discussion on this first? Seeing none. And we're being asked to have an action item before us. So is there a motion? No? No? Okay. Okay. Let's go back then. Okay, is there any more board discussion then? No? Oh, Lilia, sorry.
Good morning, Dr. Shan. No, I just wanted to support the DAC's decision. It was a very thorough discussion yesterday, and I think the outcome was good, and I approve sending it back. Thank you.
Any other board discussion? Are there any public comments? Seeing none? All right. Let's move on. We're going to move on to agenda item 21C, legislative proposal to amend BPC Division 2, Chapter 4, Article 7, title regarding dental auxiliaries, page 189 in the meeting materials. This is going to be tabled until the August 2025 Dental Assisting Council and board meetings. Let's move on to agenda item 21D, legislative proposal to amend BPC section 1753 and 1753.5 regarding authorized duties and procedures of registered dental assistants in extended functions. We're on page 190 to 196 of the meeting materials. Ms. Valerie, would you please present the materials?
Good morning. I will be presenting agenda item 21D, which begins on page 190 of your meeting materials and discusses concerns regarding the allowable duties of registered dental assistants in extended functions and a legislative proposal to resolve those concerns. As of January 1st, 2025, SB 1453 revised the duties that can be performed by RDAEFs under Business and Professions Code Section 1753.5. Two of the major changes were the removal of polish and contour existing amalgam restorations and perform post and core buildup procedures in conjunction with direct and indirect restorations. Board staff believe that polish and contour existing amalgam restorations may have been removed in error in the amendment process of SB 1453. Board staff believe this is a specialized duty that requires specific training and that it should be reinserted on the list of allowable duties for RDAEFs licensed after January 1st, 2010. We have included attachment 1 in your meeting materials, which is a legislative proposal to amend Business and Professions Code Section 1753.5 to add polish and contour existing amalgam restorations back into this section. We have also realized that the list of duties set forth in Business and Professions Code 1753 that may only be performed by RDAEFs licensed prior to January 1st, 2010, after completion of an approved course in those duties, was not updated to reflect the new RDAEF duties added and renumbered in the amendments to Business and Professions Code 1753.5, which were made by SB 1453. Board staff are recommending Business and Professions Code Section 1753, Subdivision A3B, be amended to require an RDAEF license prior to January 1st, 2010, to successfully complete a board-approved course in the updated duties. I'd be happy to answer any questions you may have.
Is there any board member discussion on this?
I have a question. Robert David, so this is cleanup legislation that's non-controversial?
Correct.
Okay, thank you.
Do we have any other board member discussion? Go ahead, Libby.
Yes, good morning again. I spoke about this at the DAC meeting, and I think that the polishing of amalgam is already included in, I don't have it in front of me, but the prior line item, let's see. Do you think that dental expanded functions, RDA and expanded functions do not get training on polishing of amalgams and composites?
So what I was told is that this specific duty of polishing the existing amalgam restorations is very specific and specialized training. And while that general line item that's in there now does seem to cover it, they just want to be very clear that it's covered in that additional training. So that's what we're proposing because it was removed.
So this entire topic is specifically about the amalgam polishing. We have to go back to legislature to add this back on? Is that just because of this? I didn't hear there was something else?
Yeah, so in 1753, there's, because there's RDAEFs licensed prior to January 1st, 2010, and those licensed after January 1st, 2010, this section covers duties for both of those. And so it's 1753 has to be amended to outline what additional education someone licensed prior to January 1st would need in order to be able to perform all of the duties EFs can perform that were licensed after January 1st, 2010.
I don't know. I would like to hear from other board members about the polishing of amalgam and how it fits in with the other line item that's already in there.
Do we have any other comments from the board members? We don't have any.
Okay, thank you.
Okay. So there's really a motion before us, an action item. So, okay, so can I get a motion? No motion? Want to do it? Okay, go ahead.
So as I understand it, Ms. Valerie, just to be clear, we're fixing things that didn't quite make it through in 1753.
We would be adding the polishing of the existing amalgam into 1753.5 and
Okay.
then fixing 1753 to reflect the duties of someone licensed prior to January 1st and someone licensed after January 1st. So it's cleanup.
Then I would like to move the legislative proposal in attachment 1 for submission to the California State Legislature to amend Business and Profession Code sections 1753 and 1753.5 regarding RDAEF duties and education requirements.
Chang, second.
Chang, second. All right.
Jen or Jen?
Chang,
Jen.
second.
So let's restate, well, we already just stated the motion. So any other board member discussion? Seeing none. Any public comments? Seeing none. Board Secretary, please call the roll and record the votes.
So the motion is to, for option 1, move to the legislative proposal in attachment 1 for submission to the California State Legislature to amend Business and Profession Code section 1753, 1753.5 regarding RDAEF duties and education requirements. Chen?
Chan, aye.
Chen, I, Cheng?
Chang, I.
Cheng, I, David?
David, I.
David, I. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, I. Forge?
Forge, aye.
Forge, I. Larin, I. Medina?
Medina, aye.
Medina, I. Olage?
Malagi, aye.
Olage, I. Thakur absent, and you?
You, I.
You, I. Thank you. Motion passes.
Thank you. All right, let's move on to agenda item 22A, 2025 tentative legislative calendar. We're on pages 197 to 199 of the meeting materials. Mr. Nelson, please present this agenda item.
Thank you, Mr. Board President. The 2025 tentative legislative calendar is being provided for information only. 2025 tentative calendar is compiled by the Office of the Assembly Chief Clerk and the Office of the Secretary of the Senate. No action is required, and this is information only. Thank you.
Thank you, Mr. Nelson. Is there any board member discussion on this item? Seeing none. Are there any public comments on this agenda item? Seeing none. Let's move on. Mr. Nelson, let's go on to agenda item 22B, legislation of interest. We're on pages 200 to 221, supplemental page 222 and 226. Mr. Nelson.
Thank you, Mr. Board President. So what we have on this agenda item is a list of priority legislation for board consideration to take an action on. And so these are the bills that we're going to discuss that impact the board. But there is also a list subsequently of other board monitored legislation that is of potential interest to the board that does not require discussion at this time. Staff will continue to watch those bills and report on their progression at future board meetings. Information regarding each of these bills, status, location, date of introduction, date of last amendment, and the summary has been included in the memorandum. Please note staff will not be presenting these bills. Should a board member desire to discuss one of these bills, they may present the bill at the meeting and provide arguments for the board to take a position. So then I will begin with discussion of priority legislation, beginning with Assembly Bill 485 regarding unsatisfied judgments. This bill would require a state agency, if an employer in an industry that is also required to obtain a license or permit from that state agency is found to have violated the unsatisfied judgment provision for non-payment of wages, to deny a new license or permit or the renewal of an existing license or permit for that employer. The bill would also require the Labor Commissioner, upon finding that an employer is conducting business in violation of that provision, to notify the applicable state agency with jurisdiction over that employee's license or permit. Impact on the board is expected to be minimal. However, staff notes there is no process in the bill for the board to issue the initial or renewal license or permit if that employer comes into compliance with the unsatisfied judgment requirements. Further, the board does not provide lists of license or permit applicants to the Labor Commissioner, so it's unclear how the Labor Commissioner would know whether the employer had applied for a board-issued license or permit. The board may wish to communicate these issues to the bill author for clarification. Our recommended position, oppose unless amended to clarify board action on the initial or renewal license or permit following subsequent compliance by the employer and resolve the issue of Labor Commissioner awareness of license or permit applications submitted to the board. So each time I'll kind of go over one of these bills and you know the process.
Okay, so we'll ask for board comment first. Any comment on AB 485? Okay, and the recommendation is,
Oppose unless amended,
okay, do we vote on that?
and to clarify those items that I mentioned.
Okay, well, let's go on and take each one because they're pretty complex. So is there any public comment? Seeing none, okay, I need a motion to adopt, oppose unless amended. Is that correct?
Yes.
Okay. Okay, I'll move that. Is there a second?
Second.
You second. Okay. Do I have public comment again? Any other public comment? Mr. Randolph, are you coming up? No. Okay. Okay, go ahead. I'm sorry.
So as part of your motion, I would recommend that right now it's oppose unless amended to clarify the various issues with the bill. And then I think the board should also delegate to the executive committee authority to work with the bill author on amendments to the bill. And then if the bill is satisfactorily amended to resolve the board's concern, authorize the executive committee to issue a change in position letter. So potentially you're just moving to a watch after the issues are resolved.
Yeah. So actually it would be kind of self-serving if I accepted the amendment. So can we have another board member comment on it? In other words, delegating the authority to the executive committee to modify the position based on the actions by the sponsor of the author.
That's right. And I don't think there's a conflict here because you are just taking action based on the board as a whole, their instruction to the executive committee.
Okay. Then as amended, then accepted. Okay.
Please repeat. Oh, the motion.
Yeah.
The motion is oppose unless amended to clarify board action on the initial or renewal license or permit following subsequent compliance by the employer and resolve the issue of Labor Commissioner awareness of license or permit applications submitted to the board, and authorize the executive committee to communicate with the bill author to resolve the board's concerns. And if the bill is amended to resolve those concerns, authorize the executive committee to change the board's position to watch.
Okay. Ditto.
I'll
So,
I'll second that. That is a new motion, which is overriding the first motion, which did not have the secondary information. So I'll second that.
caveat, yes. Okay. Any other board comments on that? Okay, any public comments on the new motion? Seeing none? Madam Secretary, let's vote on this one.
The motion is, as stated earlier by Ms. Welsh, Chan?
Chan, aye.
Chan, I, Cheng.
Chang, aye.
Please hold. Can we get, did you ask for public comment on the revised motion?
Well, let's ask for public comment.
I think you did, but if not.
Yeah, let's ask for public comment. Okay, seeing none. Okay, now,
Chan?
Chan, aye.
Chan, I, Cheng?
Chang, aye.
Cheng, I, David?
David, I.
David, I, Felsenfeld?
Felsenfeld, aye.
Felsenfeld, I, Forge?
Forge, aye.
Forge, I, Larin, I, Medina?
Medina, aye.
Medina, I, Olage?
Malagi, aye.
Olage, I, Thakur, absent, you?
You, aye.
You, I, motion passes.
Thank you. Mr. Nelson.
Thank you, Mr. Board President. The next bill is Assembly Bill 489 regarding artificial intelligence. This bill would prohibit the use of specified terms, letters, or phrases to falsely indicate or imply possession of a license or certificate to practice a healthcare profession. The bill would prohibit advice or care reports provided through AI or generative AI, the false impression that such are being provided by a natural person with the appropriate healthcare license or certificate. The board anticipates a small increase in complaints in enforcement cases. The recommended position is to watch the bill. Thank you.
Okay. Well, let's see. Let's start with board comments. Artificial intelligence is coming more and more into play.
I have a comment. Just a question, Ms. Nelson. It's saying that you cannot pretend to be something you are not. As I see it with AI, pretending you're a doctor or whatever you are. Why are we not in favor of this as opposed to watching it? What is the downside to saying we're all for that? We don't want the public being fooled. That's why we're here, not to fool the public.
Thank you, Dr. Falsenfeld. So I think the real concern is here, for example, my grandmother. She gets on an app on the phone and she doesn't know that it's not a dentist on the other side telling her something. She thinks it's a person that automatically emailed her or something like that. And so while it's hard to imagine that, you know, a lot of people would be fooled by these things, technology is very complicated for a lot of different types of folks. And it's important, I think, that the goal is to have like kind of a disclaimer, like this is not from a dentist, right? Because you need to have a license to do that. You can't just, you know, have a program spitting out emails and information to people that is pretending to be, like you say, a healthcare professional that's licensed. That's what the goal of the bill is.
I'm still not understanding. It seems you said we should watch this bill.
Yes.
And we can. That's easy enough to do because we can always go to another position down the line. But why don't we just say we're in favor of this bill because this is trying to protect the public? That's the question.
Go ahead.
Christy Bell, Assistant Executive Officer. This is your opportunity. If you want to support it, we absolutely can do that. This is just our general recommendation, but that's why we bring it to you so that you all can make that decision.
Which is my point. So thank you.
Any other board comments? Well, there's a distinction here too. License versus a dentist who may or may not have a degree, which is another stopgap. So this is the licensure part of it, not necessarily assertion of your background. Is that correct?
Yeah, the way the bill is written, it would prohibit any false impression that anything's being provided by a licensed or certified person giving that healthcare advice or report.
In that case, I would like to not take a watch position. I'd like to move that we support this. And we're going to continue to watch it anyway. And if things change in some way or other, we can always change that. But I think this is something that's very critical to our mission.
Any other comments? I'll second it to oppose, not oppose,
No,
support,
no.
support, I'm sorry, to support.
Confusing
Yeah,
enough.
yeah. Any other board comments? Are there any other public comments on this? This is an emerging area. All right. Board Secretary.
Okay, the motion is to support AB 489. Chan?
Chan, aye.
Chan, I. Chang?
Chang, aye.
Chang, I. David?
David, aye.
David, I. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, I. Forge?
Forge, aye.
Forge, I. Ladin, I. Medina?
Medina, aye.
Medina, I. Olage?
Malagi, aye.
Olage, I. Thakur, absent. You?
You, aye.
You, I. Motion passes.
Thank you. Mr. Nelson, that was a good one.
Thank you, Mr. Board President. Next bill is Assembly Bill 667 regarding interpreters. This bill would, beginning July 1st, 2026, require certain boards under the jurisdiction of the Department of Consumer Affairs to permit an applicant who cannot read, speak, or write in English to use an interpreter to interpret the English written and oral portions of the license examinations. This bill was amended recently to remove Department of Consumer Affairs Healing Arts boards, such as the Dental Board. However, board staff recommend monitoring to ensure the language is not added back. Our recommended position, of course, is to watch the bill. Thank you.
Is there any board comments on this? Do we have a motion?
I'll move the watch position.
Second.
Mr. David?
Mr. David and Indiana, second. Okay. It appears that we don't need a motion to monitor and watch. Thank you.
Thank you, Mr. Board President. The next bill is Assembly Bill 742 regarding licensed applicants who are descendants of slaves. This bill wants a process to certify descendants of American slaves is established by the proposed Bureau of Descendants of American Slavery pursuant to another bill, Senate Bill 518, would require state licensing boards to prioritize applicants seeking licensure who are descendants of American slaves. This bill is like AB 2862 last year, which the board opposed unless amended to resolve implementation, fiscal, and clarity concerns with that bill. First, as to the implementation concern for AB 742, the Business and Professions Code currently requires 4 applicant populations receive expedited review for licensure from the board. So one is members of the armed forces who have served on active duty who are honorably discharged. 2 is members of the armed forces enrolled in the U.S. Department of Defense SkillBridge program. 3rd is spouses or domestic partners of active duty members of the armed forces who are currently assigned to a duty station in California under official orders. And 4 is refugees who have been granted asylum by the Secretary of Homeland Security or the Attorney General of the United States, or those with a special immigrant visa. With all these prioritizations, it's unclear whether this bill would require the board to expedite license applications from descendants of American slaves ahead of military members and their spouses or domestic partners. Second, as to clarity concerns, the bill is unclear on what prioritize means and whether that means the board must expedite license applications from descendants of American slaves, or if the bill requires the board to do something more, such as outreach to communities or schools to encourage descendants of slaves to apply for licensure. Third, there is a concern posed by Government Code Section 12944, which prohibits any licensing board from establishing any qualification for license that has an adverse impact on any class by virtue of its race. Also, Government Code Section 11135 prohibits a state agency from denying full and equal access to the program or activity conducted by a state agency on the basis of race. The board may face constitutional challenges from applicants resulting in costly litigation to the board to defend the implementation of this bill. It may be appropriate to request clarification as to what is meant by prioritizing these applications. It is also important to request clarification as to what is meant by numerical priority in terms of what type of applicant population would get expedited processing, and require the state, not the board or its licensees, to cover all costs associated with litigating claims brought against the board due to the implementation. The recommended position is to oppose unless amended to resolve the implementation, fiscal, and clarity concerns that I just mentioned. Thank you.
Yeah, a lot of moving parts on this one. Yeah. Yeah. Oh my goodness. Are there any board comments on this? So,
Felsenfeld, this is similar to what we did last time in terms of oppose unless amended to clarify, because there's a lot of loose pieces to this that I are trying to figure out what they are. And when I hear what you're saying, it gets confusing. All right. That's the
Yes.
same thing we did last time around.
Yes, Dr. Paulson.
Thank you.
okay, since we're taking a position on this, any other board comments on this? Seeing none, do we do the motion first?
Want me to do it?
Yeah, go ahead.
I've been asked to make a motion. All right, Felsenfeld, I move that we oppose unless amended to provide clarity for us. And council, do we need to go anywhere with that relative to adding on the executive committee to make changes?
That's all of that.
My understanding is this bill is currently a 2-year bill, so the board would have additional time to opine and change its position if the bill is subsequently amended.
Thank you. My motion is, as I stated, it's simple.
Okay, is there a second? I'll do the second. Any public comment?
Which one was that?
This is
Seeing none, board secretary.
7.2.
Okay, motion is to oppose AB 742. Was that only opposed or unless amended, AB 742? Chan,
Chan, I.
Chan, I, Cheng,
Chang, I.
Chang, I, David,
David, I.
David, I, Felsenfeld,
Nelsonville, I.
Felsenfeld, I, Forge,
Forge, aye.
Forge, I, Larin, I, Medina,
Medina, aye.
Medina, I, Olage,
Lagi, aye.
Olage, I, Zakul. Absent, you,
You, I.
you, I, motion passes.
Thank you, Mr. Board President. The next bill is Assembly Bill 873 regarding the infection control course. This one's a doozy. AB 873 was introduced to resolve concerns of the California Dental Association with dental assistant infection control course requirements in BPC Section 1750. The bill would also repeal BPC Section 1755, the new infection control course, to resolve the implementation issues raised by board staff. On April 9th, 2025, AB 873 was amended in the Assembly Business and Professions Committee, and among other things, would add new fees in BPC Section 1725, Subdivision L, for review of application approval and reevaluation to offer courses in interim therapeutic restoration and radiographic decision-making and infection control. AB 873 is currently on suspense file in the Assembly Appropriations Committee, but board staff is optimistic that it will not die on suspense. Board staff have determined that BPC Section 1725 amendments requested by the board would have set new dental assistant course fees at $300, which is the same fee set in the California Code of Regulations, Title 17, Section 1022 for all other course application reviews. The Assembly Appropriations Committee analysis for the April 23rd, 2025 hearing stated, if the board charged the maximum fee of $300 to review an application, the board would experience a revenue increase of only $52,000 per year, which would not cover the total yearly costs associated with the workload. To resolve the fee concern in that analysis, board staff analyzed the workload for reviewing the new infection control course applications, as well as the new ITR and RDM, that's interim therapeutic restoration and radiographic decision-making and radiation safety courses. Board staff have determined the board would need to charge $7,300 for the ITR and RDM and radiation safety courses and $3,830 for the infection control course applications to cover the board's costs. The legislative proposal to do this would need to be presented to Assembly Member Alanis, who's the bill author, and the California Dental Association for consideration. Board staff also note that the regulatory course fees will need to be reviewed for potential increase as well. The board had communicated to the Assembly Business and Professions Committee staff that BPC Section 1755 Subdivision G to limit the use of electronic infection control course with no in-person clinical instruction to only unlicensed dental assistants in the board's requested amendments was a concern for CDA, and the board requested the committee to resolve the issue, which we feel it did by voting the bill out of committee with this provision and discussed in the committee analysis. Also, yesterday, the Dental Assisting Council met and recommended to the board as to BPC Section 1750 Subdivision C to change the time limit from 90 days in the bill for someone to get their infection control things sorted out to 30 days. They also suggested, as to 1755G, to keep the provision to limit the use of an electronic infection control course with no in-person clinical instruction to only unlicensed dental assistants. And lastly, 1725, we need, I think, a new subdivision M for fees the board would need to charge. That includes the $7,300 for the ITR, RDM, and radiation safety courses, and the $3,830 for the infection control course applications to cover the board's costs. The recommended position on this bill is support if amended to include the board's additional legislative proposals to resolve sunset bill issues. Thank you.
Thank you. Go ahead.
Just to clarify, the fees being requested that was passed out by the council yesterday, recommended to the board in BPC Section 1725. There is existing subdivision L, and the requested amendments are to apply, set the fees for the ITR, RDM, and radiation safety courses at $7,330. And then add new subdivision M for the infection control course under 1755 and set the fee for that at $3,830. Something that was not discussed yesterday, but the board should consider is also amending subdivision K, which is the fee for board approval for all other courses under regulation. Right now, the fee for that application for board approval for courses, it's a max of $2,000, and based on staff's review of all of the requirements to implement the new ITR, RDM, and radiation safety courses, that's at $7,330. We're recommending the board also request an increase to the maximum, currently 2,000, and then increase it to probably at least 8,000 as the max. That would allow the board to then utilize that higher maximum and then change the course fees that are currently set in regulation. Right now, the regulations provide for a $300 course fee to apply for board approval, but making this change in subdivision K would allow the board through the rulemaking process to increase the regulatory fee.
Thank you. 873 has a lot of moving parts, a lot of variables here. So there are three primary elements. It's about the fees, about the time to implement a provision, and then the third element seems to be applying virtual versus in person. Let's do this. Let's encourage debate, but a 2-minute time limit. If you agree, please state your name, maybe your affiliation with an organization, and just aye or nay. 2 minutes though, okay? So is there any, go ahead.
Yes, I have a question. I heard this yesterday also, and I should have asked it maybe yesterday. Oh, I couldn't ask it yesterday. I was in the audience. The $7,300 for those 3 courses, is that per course or for the package? Are we talking $21,000? Are we talking $7,000 for me to send my assistant to take any of those courses?
No, it's not for a student to take a course. This is for a course provider to apply to the board for board approval. And so that fee, that $7,330 would be per course.
For them to provide, I want to give course A, B, or C, 21,000 if it's 3, but I'm a provider, not the student.
That's right.
And our student fee is still going to be 300 at this point, or we want to raise that as well?
The number in regulation for, all of the regulatory courses, Pitt and Fisher, sealants and corona polishing, all of that, it's currently 300 in regulation. And then the board would have to review through the rulemaking process to increase the fee set in regulation.
That will be another day. Okay,
And I
thank you.
have another
That makes more sense to me because I was very unclear on that.
And I have a question about what you're asking. So now you're saying that you,
Speak it to the mic.
okay, I have another question about what you're asking. You're saying it was that the 7 is not sufficient, that you want to increase it even more to closer to 8. Is that what you're saying too?
Under subdivision K, there's currently a maximum that can be charged for this board approval application of $2,000. And we're proposing to increase that 2,000 to at least 8,000 to cover the board staff time on the existing courses.
And if to add on to Ms. Welch's statement there, just as a point of clarification, these fees are for providers of these courses. And if you were to look at the open market, I don't want to give specifics, but my analysis on this and my estimate is that the board is actually offering a deal, comparatively speaking, to do accrediting, to do all of this. I mean, basically every 7 years, you pay this fee, and for 7 years, you have this ability to do these courses. If you were to go to an accrediting agency, these fees can climb quite high. They can be as much as, I mean, I'm sure some of you know how much those fees are and how vague and unavailable this information really is. It's not transparent always, depending on the accreditor. But there isn't just the initial fee like we charge. There's also even, with some of these accreditors, an annual fee of like $2,000 every year. And that's if they don't show up and find things that they don't like. So this is a very costly thing for the board to do. It requires a lot of staff time and resources, and that is why you see that cost there. It's something that when accrediting agencies do this, they charge significantly more. And I just want to make that clarification. Thank you.
Question,
Go ahead.
Robert David. Are the fee payers in this regard, are they aware that, I mean, this is a whopping fee increase. Are they going to have a chance to comment during this process or?
Yeah.
Well, go ahead, Ms. Walsh.
This is the process. This is,
Yeah.
you know, the board is going to be recommending to the bill author to include these amendments in AB 873. So the public can provide their comments on the board's proposal here right now. And then there's also a public comment process on AB 873 as that bill moves through committee. So providers can also submit their public comments to the legislature directly.
Thank you.
I've got one other note to make here. Right now, AB 873 only includes 3 code sections, Business and Professions Code Section 1725, 1750, and 1755. After the February board meeting, the board requested that additional sections be added to AB 873. Board staff submitted that legislative proposal to add the additional sections in March. The additional sections approved by the board at the February meeting have not been added to the bill yet. So that's why, in addition to the proposed amendments we've discussed today, the board also needs to see the additional sections that it requested back in March that the bill's author agreed to amend into the bill at the Assembly Business and Professions Committee.
Okay. Any other board comments? Again, there are a lot of moving parts to this that are constantly shifting on us. Any other board comments? Okay. We do the motion first or?
Well, we have to figure out how we're going to deal with this.
Yeah, let's do public comment because there are a lot of moving parts on this thing.
Good morning. Pam Congdon from the California Association of Oral and Maxillofacial Surgeons, also known as CalAMAS. Just to add more to this complicated bill, we do support it, but we'd like to propose that the 32 hours of the DSA clinical lab and preclinical portions of the DSA be taught in extramural facilities. This change would allow training and testing to be controlled and standardized in a standardized environment, with calibrated instructors, improving both access and ultimately enhancing patient safety. None of the lab and preclinical skills require a clinical environment. All clinical skills involving patients would obviously be done in the instructor's and doctor's office. Our goal with this proposal is for patient safety and permitted assistance. I assume this was the demo board's goal in 2010 when this first started. We are asking to make the training part of the DSA more efficient, not easier. Let CalAMAS, CDA, and other organizations that have DSA approved instructors help do that. I gave Christy more information on this subject.
Go ahead.
As a point of clarification, could you tell us what Business and Professions Code section you're requesting be amended to accomplish your statements?
I don't know that.
Can you submit that in writing then?
Okay.
My concern is that I don't think there are a lot of course requirements for the DSA courses in statute. I think those are in regulation. So I'm not clear on how revisions to AB 873 could accomplish your goal. I
Okay.
think that might be a rulemaking.
Okay,
Thank you.
thank you.
Thank you. Any other public comment? Come on down. 2-minute warnings. Good morning.
Good morning. Melody Randolph, representing the Alliance. First comment in relation to the fee increase, just to keep in mind that those are significant fee increases. And of course, those increases would be passed along to the students taking the courses potentially. And so I think the ramifications of that would be that eventually the courses will be a lot more expensive for the people taking the courses. So something to think about. In reference to the infection control, the 30-day requirement, again, keeping in mind that if there's going to be a virtual online only component, 8 hours for online, 30 days is sufficient to take an 8-hour course online. So we would encourage you to, and that is a compromise. You know, currently we all know that the infection control is supposed to be done prior to potential exposure to blood and OPIM. So going to 90 days to do an 8-hour course is just more time than is needed. For the comment CDA had in their letter regarding the retaking of the course being redundant, so that the virtual only being for DA, and then in order to get licensure or permit to have to take the hands-on component, doesn't make sense. Their comment about it being redundant, in that all of us, I've been in dentistry 35 years, and every 2 years I have to take an infection control class to renew my license. So their argument that it's redundant and unnecessary, actually for somebody who is brand new, if I have to do it every 2 years because I might forget after 35 years, somebody who is brand new needs that information more than once. Thank you.
Sherry Becker with the Alliance. I concur with Melody Randolph's comments. Thank you.
Thank you. Yeah. Good morning.
Good morning, Tuka Zokai with CDA, respectfully urging the dental board to modify its position on 873 to a support position and to respond to some of the items raised. We understand the fee increase is necessary and was a very carefully calculated review by the board. For the 30 to 90, 120 days, to just clarify that piece, that prior to 2025, it was 120 days of consecutive employment and then 1 year to complete the course. As of 2025, that moved to before exposure to blood and saliva, and 54% of CDA member calls were about this being impossible to meet. There weren't classes. This was affecting providers in rural areas who didn't have a course option. We do talk about the virtual course option, but that currently doesn't exist. There is no virtually available online course, and we don't know when that will become available. We're of course enthusiastic for that to one day become an option of a board-approved 8-hour infection control course, but the reality is it currently doesn't exist, and this has been inaccessible for so many providers that want to hire. So we have recommended to move to 90 days, which is still a 9-month reduction in what was prior to 2025 in terms of the time to take this 8-hour course. So we believe that 90 days is extremely reasonable, considering that there is also the Cal OSHA mandated infection control training that is also required annually. We take infection control extremely seriously, and we heard many comments yesterday and today about the importance of infection control and how this is part of the dental team's culture, and it needs to also be trained by the supervising dentist to make sure there is compliance. With that, we really think the 90 days is an appropriate time frame to complete this course. For 1755G, we do also see that dental assistants retaking the exact same infection control course in person.
Thank you. Thank you.
Okay. Bruce Witcher, CDA. First echoing many of Ms. Okai's comments, but also speaking to the point about the retaking of the course, it's going to be essentially the same course. It will be given in whatever format is available, hopefully online. When RDAs are going through their program, they'll take the same course as the online course and have consistency across the board, I think makes a lot of sense. And with respect to the 90 days, there's a lot going on within that 90 days. You have to get these new hires geared up to where they're going to get something out of the course. It's going to take some preparation time. To get that done in 30 days and have them complete the course in a meaningful way is going to be very difficult. So we would really appreciate it if you would amend your position and support the proposal as we're recommending. Thank you.
Thank you. Thank you. Any other public comment? Good morning. And state your name.
Good morning. My name is Harry Doherty, and I'm representing the California Association of Orthodontists, 1,500 practicing orthodontists in the state of California. As you noted, that 873 is kind of a bill to clean things up, and so we have some things we would like to think about that. I want to thank the board for their work on SB 1453 and the removal of the experience requirements. This is a huge win for the workforce development in orthodontics, and we deeply appreciate your leadership. However, one issue remains unresolved, and that's the ultrasonic scaling course requirement. This requirement was codified in SB 1453, but remains malaligned with the scope of orthodontic practice. Ultrasonic scaling is not used in orthodontics, and it is a procedure used in general dentistry for heavy calculus removal. Orthodontic assistants don't perform this task, and yet they're required to complete costly and hard-to-access courses that have no relevance in today's day-to-day duties. We've made 3 formal requests to have this issue placed on the agenda in November, February, and May without success. We submitted a letter by the CAO, signed by more orthodontists across the state asking for discussion, yet this item has never been agendized. We are formally requesting today that ultrasonic scaling requirement be placed on the agenda for August meeting, and that we be connected with the appropriate staff to help us in the conversion in this conversation forward. If this issue had been addressed in any previous meeting or today's, we could be working on legislative solutions to address it before the implementation further impacts workforce development. That's why it is so important that we take action now. There seems to be an appropriate vehicle, AB 783, that could allow us to address this issue this session. We want to work with the board to provide all of the information necessary for your understanding why this requirement needs to be removed, and get your feedback, and then amend the resolution to AB 873. We're ready to work collaboratively with the board on this solution. We do support, the California Association of Orthodontists do support AB 783, and I want to thank you guys for your time. Appreciate it.
Thank you. There is an opportunity for posing future agenda items, and that might be an avenue to consider.
I appreciate that. Thank you for your time.
You know,
Doherty,
submitting it
could
in
you
writing.
leave your message with us? Just hand it to
In
staff
writing,
and
yes.
that will, thank you.
Yes. Public comments. Well, you already commented once, and the rules are, yeah, sorry. Any other public comments? Just for the audience, the rules, you only have an opportunity of one time, and you have the time limit. Otherwise, it's unfair for any other public comments. Any other public comments? Okay, here goes. Do we have a motion? There's so many pieces to this thing.
I'd like to request, is there a chance that we could actually look at this as a 3-part bill or a 4-part bill and do one at a time to see what our position would be? Because we may want to do A from one part, B from the other part, and to say, can we get a motion with all of things in one place? I don't think that's going to work easily, but that's a doable thing.
Yeah. We have 3 variables here. The variables are about the fees. The variable is about the time frame to implement. And the third element is the alteration of virtual or not alteration, but modification of virtual and in person. So there's 3 variables that seem to be on the table for discussion.
I think we also have the timing, 30 versus 90 or 120, or whatever.
Time to implement.
That's another thing. That's 4 parts to the thing.
No, that's still 3. So at issue is Business and Professions Code Section 1725, that's fees. 1750, that's the time frame for an unlicensed dental assistant to complete infection control prior to being exposed to infectious material. And Business and Professions Code Section 1755, and that's the issue that subdivision G has been added to that Business and Professions Code section. The board requested that. This is to limit the use of the electronic infection control course to only unlicensed dental assistants, and that electronic course that does not have a clinical instruction component that could not be used when applying for RDA, RDAEF licensure, or OA and DSA permits. That's the issue. The board wanted that limitation in the bill. You voted on that in February. We submitted that request to the author as well as the Assembly Business and Professions Committee. We knew that CDA had concerns about that limitation. So we asked the B&P committee to resolve the issue. And it seemed that they had, because they went ahead and added subdivision G to 1755 to limit the use of that electronic infection control course to only unlicensed dental assistants. So right now, as far as the board's February vote, that issue has been resolved. However, CDA has submitted written arguments in support of removing subdivision G for your consideration. So do you want to start with 1725 fees?
Tara, Tara,
That's
are we able to vote these?
Go ahead.
Okay, Tara,
Turn on your mic. Turn on your mic.
is it on? Are we able to vote these issues separately that way from versus one lump sum? Because I think it will make it easier. I agree with Dr. Felsenfeld and Dr. Chan that way, because the way it is now, it's confusing and it seems to get lumped together. So are we able to do that? That's what I need clarity on.
Go ahead, Alan.
If I may go back to my parliamentary geekism, we are allowed to take a bill or any kind of a resolution that has multiple parts, and if they are not dependent on each other, then we could break it into the parts. We can accept each of them and then take the whole thing and the bill as a whole.
Okay.
So if that's, in council, we've done that before, right?
You can do that, but then you're going to need a fourth vote because there are missing pieces from AB 873 that you want to continue to request to be added to that bill. So those are all the provisions or the proposals you adopted in last November and February. So we still need those added to the bill. So that would be a fourth motion.
But we can do them one at a time so that we
Sure.
clarify our position. That's the whole point. It'd be a lot easier to do that. So have at it.
Okay. Well, let's try to tackle this elephant. And no metaphors intended. Let's see. Can I get a motion? Let's start with the fee part. Can I get a motion on that? Go ahead. Okay.
We need language, but basically, we are going to move, I can move that the fees that are proposed by staff for the cost to the provider to be approved for the courses be accepted.
Dr. Ford, second. Okay, is there any public comment? Any board comment first? Go ahead.
So to be clear, the motion is to propose amendments to Business and Professions Code Section 1725 to revise subdivision L to apply that only to ITR, RDM, and radiation safety course applications, and to set the fee for that application at $7,330, and then add new subdivision M to set the course fee for the 1755 infection control course at $3,830. And my question to you is, are you also approving an increase in subdivision K for all of the other course applications? Okay, so
That gives us the cushion, the 8,000 is what you're suggesting, yes?
that's right.
Okay. Just for those who don't understand what we're talking about, we can set a fee in statute, but then that's it, we're stuck with it.
Yeah.
Whereas if we set a fee and a cap, we can then increase it as we need to.
Right.
So that took me a long time to learn, I've been here for a while.
And part of that motion is to request that these proposed revisions to 1725 be added to AB 873.
That's correct.
That is what I am asking to do. We're going to use the legal language. Thank you, counsel, because we didn't have that in front of us.
Is there a second?
Ford.
Dr. Ford,
Ford,
second. Okay. Public comment.
CDA, speaking in support.
Say again?
Speaking in support of the
Please
motion.
State your name. State your name. It's Dr. Witcher.
Now.
Any other public comment?
now
Yes, now you can.
Sherry Becker, representing the Alliance. Just stating concern for the course providers with such a large increase. Also just stating concern for the students as well, as those costs will need to be passed forward. So thank you.
Thank you. Any other public comment? Okay, let's take this part of the elephant. Board Secretary.
Motion as stated by Ms. Welch, Chen,
Chan, aye.
Chen, I, Cheng,
Chang, I.
Cheng, I, David,
David, nay.
David, no. Felsenfeld,
Felsenfeld, it's got to be corrected as stated by me because the attorney can't make motions here, if I'm not mistaken. But the language was from the attorney and the answer,
Oh.
I vote yes. It's not stated by Ms. Welch, it's my language that she has given me relative to that. A board member has to make the motion.
Yeah.
She cannot, I did that.
The motion.
But the answer is yes.
okay. Felsenfeld, yes. Forge,
Forge, aye.
Forge, I, Larin, I, Medina,
Medina, aye.
Medina, I, Olagi,
Olagi, aye.
Olagi, I, Thakur absent, you,
You, I.
you, I, motion passes.
Thank you. Okay, we're on to the second element, is the time frame to implement, and it discusses the change from from November, from 120 to the proposed 90 to the, go ahead. Go ahead.
All right, so we're looking at Business and Professions Code, Section 1750, Subdivision C, with respect to the requirement for an unlicensed dental assistant to complete an infection control course prior to being exposed to infectious material and working with patients. To be clear, the current requirement under 1750 is to take the infection control course prior to exposure to infectious material. So before you begin basic dental procedures with the potential exposure for OPIM, you have to complete the infection control course. AB 873 currently is changing that immediate requirement to a 90-day requirement. So you get hired and you have 90 days to take the infection control course. The Dental Assisting Council submitted their recommendation to the board to change that 90 days to 30 days.
Okay, is that clear? All right, let's ask for board comment first. Any board comment? And that's the shifting that's requested from the 90-day that's on the table to the 30-day. Go ahead, Dan.
Once again, for clarity, because I need clarity a lot and my math is not good either, we are looking to suggest, or we're suggesting, and I'm hearing that it would be nice to have 30 days, but the availability of courses, because we don't have an 8-hour virtual course yet, to go in there, they can't go take it the day they get hired and then go start working 2 days later. And it's going to take time for them to do it. So the 90 days makes sense to me, and that's.
I want to second Dr. Felsefield's comment. The 90 days makes sense to me for everyone involved. Consumers, stakeholders, the dental assistants, the employers, if we look at a board to consider 90 days.
Thank you. Thank you. Any other board comments on this? Go ahead.
The way it was taking it before is very difficult for many. The way that the staffing is, the staffing shortages we have right now, sometimes we hire an assistant and they don't show up the next day, but they took the course. So that would be another issue that might come up later. I mean, they want to take the course, but they don't want to work with you. And so that to me is a part that, and it has happened. I know people that have hired assistants, when they hire them, they don't show up. And also, that might just work a week or two and they're gone. So that's another aspect of this that would be difficult to control. And I do support the 30 days. I mean, the 90 days.
Thank you. Any other board comments on this? Let's do the public comment and then let's do the motion. Wait, the motion's on the table?
I don't think we have an absolute motion yet. We have
Okay.
some concurrence that 90 days makes sense among some of us, but
Let's do the public comment so that we hear them out. Okay,
And
any
then we'll-
public comment? Any public comment on this? Yeah, I know.
I'm Sherry Becker, representing the Alliance. Just as a reminder, there was regulation in place since 2010 that allowed after 120 days, you had 12 months as an unlicensed dental assistant to acquire this course, which did include 4 hours of lab/clinical experience. So, and also just as a reminder too, that the language of prior to was previously approved by the board.
Thank you. Okay, any other public comment? We're talking specifically about the time frame to implement.
Thank you. Tuka Zokai from California Dental Association. I just want to thank the board for considering this 90 days as currently being proposed in AB 873, especially since we've heard so many different concerns by our member dentists about the challenges to taking this course. While, as of 2025, it was changed to prior to exposure to blood and saliva, we saw that language has really prohibited the ability for hiring. It's caused staffing shortages. It's caused hiring challenges. The course hasn't been available. So we just really want to emphasize and thank this approach for the 90 days. It's still a significant reduction in the time frame from prior to 2025, but it still is going to support the dental team, the assistants, the dentist, and the consumer. So we just thank you for the consideration of 90 days.
Thank you. Any other public comment? Yes.
My name
morning.
is Marina, and I just have a personal.
State your name again.
Marina. And, well, I'm sorry. I just have a personal suggestion. As a dental assistant, what about a online training that the employer would provide to their assistants before putting them on the floor? That is
We're going
just
to
a
tackle that
suggestion.
as another element in here.
Just while the assistant gets to get the 8-hour infection control training. It's just a suggestion. Thank you.
Thank you. Any other public comment? Okay, let's do the motion then. Okay.
why don't you just leave to help us with the legal language? And
Let's do the legal language.
Mr. Welch, can you please help us with the motion language?
Yeah, the legal aspect of where to put it, and then we could use that.
So right now, all I've heard is support for a 90-day component. So the motion would be to propose an amendment to Business and Professions Code Section 1750 Subdivision C to change to support the 90 days that's currently in AB 873. So there would be no requested amendments to the current Subdivision C.
Okay. I got a motion on that.
Dr. Loren?
Yes?
Yes, I make a motion.
I thought it was a meeting. Olagi, second.
We got second? Olagi? Olagi, second. All right. Yeah, okay. We already had public comment on this, so, right. Okay. Oh, my goodness. Okay. In fairness, let's let another opportunity for public comment. Seeing none. Madam Secretary.
The motion is as read by Ms. Welsh and the a motion by myself, seconded by Olage.
Olagi, yes.
Okay, Chan?
Chan, aye.
Chan, I. Chang?
Tang, aye.
Chang, I. David?
David, I.
David, I. Felsenfeld?
Felsenfeld, yes.
Felsenfeld, I. Forge?
Forge, aye.
Forge, I. Ladine, I. Medina?
Medina, aye.
Medina, I. Olage?
Olagi, aye.
Olage, I. Thakur absent. You?
You, aye.
You, I. Motion passes.
All right, thank you. Thank you. Okay, we're on the third element now. The third element is the implementation of the question of virtual, in-person, and the timing on that, or the overlap on that. So go ahead.
You're looking at Business and Professions Code Section 1755, new subdivision G that was added in the Assembly Business and Professions Committee into AB 873. Right now, subdivision G does implement the board's request from its February meeting to limit the use of the electronic infection control course to only unlicensed dental assistants and could not be used for RDA, RDA-EF licensure or OA or DSA permits. So you're looking to see if you want to maintain subdivision G or if you want to agree with CDA to remove subdivision G from 1755 and AB 873.
Okay. Any board comment? Okay, seeing none. Any public comment?
Melody Randolph, representing the Alliance. We'd like to remind the
Go ahead.
Okay, we'd like to remind the board that removing subdivision G would set a precedent that you are allowing two different educational experiences for the same license. People that go through an RDA approved program have the hands-on training for infection control and are required to have the hands-on training for infection control. Now, if you don't require that of the DA, when they become an RDA, you're setting a precedent for two different requirements, two different pathways for the same licensure. We would strongly support keeping G in the bill. Thank you.
Thank you. Public comment, more public comment.
All right, get my 2 minutes back. Hello, Tuka Zokai with the California Dental Association. We're definitely in support of removing provision G and that there shouldn't be a requirement for the same course to be taken. Again, if there becomes an online available course, which again currently does not exist, it would need to meet the same standards. Now, there was the comment about two different educational experiences, but the course, the 8-hour infection control course, should be meeting the same competencies as an in-person course. Now, there may not be the hands-on experience, but there is significant hands-on experience when going through the training to become a registered dental assistant through the process of applying as well. So there's going to be a certain level of experience. Now, if the course was taken online as an unlicensed dental assistant, and then there's the application for licensure. There's still going to be a process to go through that experience. There's also the required Cal OSHA training and annual infection control education requirements. So there's still going to be significant education. We do not want to create a barrier to licensure, and the level of exposure does not substantially change when an assistant becomes licensed, making an additional in-person infection control course unnecessary. In all, we see that this is an appropriate measure to, as being proposed by CDA.
Thank you.
Bruce Witcher, CDA, just seconding Ms. Okai's comments. Thank you.
Thank you. Any other public comment? Come on down.
Sherry Becker, representing Sherry Becker. I would just like to have the board consider that we need to do a CPR class with a hands-on component, and we need to do our coronal polish class for the unlicensed DA with a hands-on component. And I think that infection control is a very important piece for the unlicensed dental assistant, whether going for licensure or not going for licensure. And so I would ask the board to consider maintaining the hands-on lab portion, regardless, I guess, whether or not they were going for licensure or not going for licensure. Thank you.
Thank you. Any other public comment? Seeing none, I think we're ready for a motion. Motion from the board? And then for clarity, we're talking about the question of virtual additioning or eliminating the in-person requirement. Is that correct? No? Go ahead.
Once again, council, would you be kind enough to clarify what we're looking at? Because this is very confusing and we want to be sure we're voting on the right thing.
Thank you.
All right, so Business and Professions Code Section 1755, Subdivision G, as shown in AB 873, limits the use of an electronic infection control course to only unlicensed dental assistants and would require an individual applying for RDA or RDA-EF licensure or the dental assisting permits to complete a different infection control course with the clinical instruction component. So G is already in the bill. And if you want to remove subdivision G so that anyone applying for RDA licensure or the permits could take the electronic infection control course with no clinical instruction, you would move to remove subdivision G from BPC section 1755 in AB 873. If you want to keep the limitation in subdivision G, you would make no motion. That's already in there and it reflects the board's February vote.
Got it. So is there a motion? Seeing none, it remains, correct?
That should be clear. Once again, let put on my geek hat. If you don't do anything, nothing changes. We haven't removed section G. If we do make a motion to remove section G and it passes, section G will go. If we make a motion to remove section G and it does not pass, then we're back to where it is and we're done.
Well, it's like a double negative, huh?
I will move that we remove section G, get that up for discussion, and see how the board feels about that.
All right. Do I get a second on that?
Olagi second.
Loggy second. Okay. Any other
This
board
will-
comment? Go ahead.
Remove the practical part, clinical part of that will remove, yes, okay, yeah. Understood.
Okay.
Public comment on it.
The public comment on the motion. Again, repeat the motion again, because we're talking about,
The motion is to remove section G from, I don't know, the 1755.
As it is appearing in AB 873.
thank you. Ms. Valerie.
I just wanted to make one clarification that maybe hasn't been brought up. But essentially removing G also will change the standard from someone going through an RDA program versus someone going through a work experience pathway. So those going through the work experience pathway would be allowed to take the virtual infection control course, but those going through an RDA educational program would be required to take the clinical portion. So it's two different standards, and I just wanted to make sure you guys were aware of that.
Public comment.
Hello, Tukazo Kai, CDA. We don't believe that it's two different standards because it should be the same course, and through work experience, having that hands-on experience is that through the experience of that training pathway. So the course itself for infection control should be the same. So we support removing G as proposed.
Thank you. Any other public comment? Yeah, for this one. Yeah, on the motion.
Sherry Becker, representing the Alliance. We oppose the proposed motion
To remove.
to remove section G. Thank you.
Thank you. Any other public comment? I think we're ready for a vote.
The motion was to remove section G from 1755. Okay, Chan,
No.
Cheng,
No.
David,
Nay.
Felsenfeld,
Yes. Felsfeld, yes.
Felsenfeld, yes. Forge,
No.
Forge, no. Larin, yes. Medina,
Medina, yes.
Medina, yes. Olage,
Olagi, yes.
Olage, yes. Takur, absent. You,
You, yes.
you, yes. So 1, 2, 3, 4, 5, 4.
Which way?
Motion passes. Okay.
Okay, thank you. All right. Now we're on the fourth element. Okay. Go ahead.
All right, so your fourth motion, staff is recommending that you support if amended to add the board's previously submitted legislative proposals from its November and February meetings and include the proposed revisions as discussed today for Business and Professions Code Section 1725 and 1755.
Thank you. Thank you.
Oh,
Go ahead.
yeah, that's right, because you voted to support 90 days, so there's no change to that.
Right.
Okay.
Right. Right. Okay, any other board comment? Public comment?
Just a point of information. I believe the bill was heavily amended.
Identify yourself.
I'm sorry, Bruce Witcher, CDA. The bill was heavily amended, and that finally came out in print just yesterday. And I think if you look at it, you'll see the elements that you asked for are included in there. It just took a little while for the, various wheels to turn to get that into print. So just take a look at it, and I think you'll see what you need. Thank you.
All right. Any other public comment? I think we're ready. Make a motion? Someone make a motion? Clarify what we're voting on. That the amendments, the proposal made back in the November meeting and then in February
That's today.
are in effect today, correct?
Just and the legislative, the changes discussed today.
And the changes discussed today. Thank you. That's a big elephant.
I make a motion.
Okay, so just to add to that motion, which is support if amended to include the board's previously submitted legislative proposals from its November and February meetings, as well as additional amendments to Business and Professions Code Section 1725 and 1755. Include those in AB 873, and if the bill is amended as requested by the board, authorize the executive committee to change the board's position to support.
Any board comment?
Yes, Felsenfeld, if in fact, and Dr. Witcher said that it's already in there, but if in fact it's not, even if it is, doing that gives us flexibility on this, that if it gets amended, we can then change to support without if amended. That's a no-brainer to me. All right, so that's fine. And that's been moved already?
Yes.
Okay, thank you.
Yeah, who moved it? I'm sorry.
I'll second it.
Who moved it? I'll move it. Go ahead. And then Felsenfeld second. Any other board discussion? All right, Board Secretary, let's see where we are.
The motion is as read by Ms. Welsh and,
Do we need more public, council, do we need more public on this now that the motion's been officially included?
More public, okay, public comment.
I've been trained.
Yeah.
I've been schooled.
Seeing none?
It's not, okay.
All right, now,
okay, so the motion, it was read by Ms. Welsh and motion by myself and seconded by Felsenfeld. Chan?
Chan, aye.
Chan, I. Chang?
Chang, aye.
Chang, I. David?
David, I.
David, I. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, I. Forge?
Forge, aye.
Forge, I. Larin, I. Medina?
Medina, aye.
Medina, I. Olage?
Olage, aye.
Olage, I. Thakur, absent. You?
You, aye.
You, I. Motion passed.
We're done. We're done.
Yes.
Okay. Take a minute break. Oh, great. First of all, thank you, board members. Thank you, public. This was big. This was big. There had a lot of moving parts. So thank you. And thank you, staff, for helping to sort out what we're talking about, because there are a lot of moving parts on here. Let's take a 10-minute break and then come back. Thank you. See. We are on. We're back in order. We are on agenda item 23, public comment on future agenda items.
We're not done with the legislation.
Oh, we're not done with the legislation. I'm sorry, Mr. Nelson. We got more. Sorry. Okay. Go ahead, Mr. Nelson.
Thank you, Mr. Board President. The next bill is AB 966 regarding foreign dental schools. Beginning January 1st, 2024, existing law requires foreign dental schools seeking approval by the board to complete the international consultative accreditation process with CODA. Existing law maintained the approval of any foreign dental schools whose program was renewed by the board prior to January 1st, though any date between January 1st, 2024 and June 30th, 2026 through the renewal date. This bill would instead maintain the approval of any foreign dental school program approved by the board prior to January 1st, 2024 until the school is denied accreditation by CODA and the school does not appeal. The school has been issued a denial by CODA following completion of the appeals process, or the school withdraws its application for CODA accreditation. The bill would require applicants who graduated from a foreign dental school with extended board approval to agree to practice dentistry in specified practice settings. This bill would further require the board, as part of its sunset review, to report specified information regarding workforce data of licensees and graduates of foreign dental schools. Board staff believe this bill would require significant statutory and regulatory changes and staff time preparing the new workforce report required under this bill and increased staff resource costs. It could also result in decreased consumer protection resulting from licensees who graduated from a foreign dental school that had not been audited or otherwise reviewed for education requirement compliance for many years. This bill may also result in a foreign dental school maintaining board approval without board oversight of compliance with existing regulatory requirements for a long time, as long as the school had applied for CODA approval. The recommended board position is opposed. Thank you.
You motion to oppose.
Yes.
Recommending to the board.
Yes, thank you, Doctor. Yeah, the position recommendation is opposed.
Okay, well,
My goodness, we already have a motion before us.
But let me ask for board comment first.
Did you make the motion?
Is there a second for the motion to oppose?
I'll second it.
Rosenfeld opposed. Let's do board comment first.
Is there any, Robert David, I mean, are there any, well, first question, is this bill still moving? It's an active bill.
So my understanding is it's now a 2-year bill, so this is not something that's imminent. However, it is important that we take a position on this bill now.
All right. I'm in support of the motion.
Any other board comment? Go ahead.
I know this is a sensitive topic, Latin speaking, and we've been through this many, many times. But back when we voted to not have the foreign dental school continue, we were told that CODA would be a quick process. And in fact, it has not become a quick process. It had been a very lengthy process. And I know for a fact that the school in Mexico has tried, attempted, it needed more changes to how they provide the curriculum and several issues were happening. And right now, it's CODA they want another CODA review. They're not going to schedule that until 2027. CODA has told them that it's going to take that long to just go look at the new school. And right now, there are many graduates that have not been able to complete their requirements. And I was just hoping we can get a little bit extra time, maybe not until it's denied, but at least 3 years, and that's 3 years to give them a little bit extra time just because of the length of the time that CODA has been taking to provide this. Also, in regards to the school, because it's a foreign school, it's not equivalent. ADEX right now is providing exams at the university. And so the school has requirements that comply with all the ADEX testing requirements. And I know that the percentage of pass and fail rate is identical or very, very close to the United States. We have a good record from the school in La Salle. The students, I have not seen any complaints come through. Myself, I have not seen any of the foreign graduates from anybody that's a graduate there, honestly. And these dentists are also working in underserved areas. It's been also explained at our last meetings that most of them are providing services and providing access to care for California. It was approved because of the language skills and the cultural background that these students may come back to serve in California, and it has provided that. And many of these students are going back to federally qualified clinics, to underserved areas, and it has been proven. There's been provided a list of all these students where they're serving. So if we're gonna oppose this at some point, I don't know where it could be done, that if we can maybe just extend it a little bit and put a deadline. I know it's a lot of work. I know it is, and there's a lot of controversy about this, but just consider access to care issues and providing a home for the 40% of Latino that live in the state of California. They always feel better when there's a cultural component to the health provider. They feel more comfortable. They'll access this care. So I'm I'm not saying that I would like to recommend just watch it. Thank you.
Any other comment from the board?
I would, this is Board Member Joni Forge. I would support.
Speaking to the mic.
I would support watching it as well, because last year we had representatives come in. We had a CODA that gave a presentation about the CODA process. We had someone come in from the different schools that talked about the contribution that these students make. I would, I don't want to just out and out, oppose this position. I would like to at least give it an opportunity to at least watch this bill at this time. So, I totally would support this.
Any other public comment? Board comment? Let's have public, go ahead.
Medina, I would like to support this or watch this bill.
Just a reminder, this is Tara Welch. Supporting a watch position will not improve the text in the bill. We've got implementation concerns, and more importantly, the board has not audited the foreign dental school programs in over 7 years at least. And right now, the proposal in the bill would extend board approval indefinitely. And the board, there's no additional audit requirement at all. There's no need to continue to apply for board approval. So the board cannot ensure the protection of the students taking those foreign dental school programs and subsequently the protection of the consumer receiving services from the foreign dental school graduates. So if you wanted to watch the bill, perhaps it would be better to oppose unless amended and then give some kind of instruction as to a better implementation of the bill.
Well, let's do any other board comment, given that piece. Okay, we had a motion to oppose. Do I have a second on it? And Felsenfeld is a second. Okay, so now the question is on the table. Is there any public comment? Go ahead. Come on in. And identify yourself, please.
Yes, my name is Dr. Vakar Chowdhury. I'm a DDS, I'm a dentist. And I have respectfully, I would like to submit a suggestion. And it is based on, because of my personal knowledge, I've been in this profession about 35 years. And also, I love this profession. And also, I know personally 2 examples. Very, I can give separately, if information is needed in detail. And one is somebody I know personally, originally they did dentistry 4-year program in outside of the US or in 8 years. So this is somebody who himself accepted, I didn't even want to be in this profession. And then that person comes to US, could not get in here to any dental school for 9 years. And then they go to Eastern Europe from 2018 to 2020, and they do a 2-year program. And he told me multiple times that it was all about money. And they, the clinical, particularly clinical training was so less, very sporadic, some sessions, and there were some, the guy spent more time in here while studying there. And now he's in California. He's a licensed dentist, and he has to change job every couple of months because wherever he goes, the people know whoever he starts working, they know the level of training and experience, the patients are suffering, so they let him go. And my suggestion is instead of a foreign.
Thank you. We had a 2-minute. So thank you.
Sorry, sir.
Thank you.
Sorry.
Thank you. Do we have any other public comment? Seeing none. I think it's on the table. So the motion is to continue to oppose the bill.
The motion is to oppose.
It is to oppose. That's right. Okay, thank you. All right. Board Secretary.
Okay, motion to approve, the number of the bill was, let's see,
966.
966. Motion to approve Bill 966.
To oppose.
Oppose. 10.
Aye.
Chang.
Chang, no.
Chang, aye. David?
David, aye.
David.
Excuse me. Excuse me.
Chang, no.
Oh, no, I'm sorry. There's me right here. Okay, David? David, aye. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, aye. Forge? Forge, no. Larin, no. Medina?
Medina, no.
Medina, no. Olage?
Olagi, no.
Olage, no. Thakur? Oh, I'm sorry. Absent? You?
You, aye.
You, aye. 1, 2, 3. Motion, fails.
Fails. Okay. So do we have another motion? Seeing none. Do we have a watch group?
By definition, we have a motion.
I would move oppose unless amended.
There you go.
Go ahead, Bob.
Yeah, I would move oppose unless amended.
Second.
That's David and then Medina. Yes. All right.
Can I get some clarity on the potential amendments to remove the opposition? Would it be to amend to resolve the concerns raised by staff, or just to set an end date for board approval? I know Dr. Larin proposed a 3-year deadline, but if you could give us a little bit more guidance on what the amendments might be that would remove the opposition.
Well, because it's a 2-year bill, I don't know that we.
Bob, speak up closer.
Because it's a 2-year bill now, it's dead for this year, correct? I think we can have a fuller discussion about this. This will come up again probably next year.
That's my understanding.
I think there's some problems with the bill. I also think there are issues with access for lower income people and people of color that are real issues that a number on the board have raised. But I don't know that we need to offer amendments at this time.
As far as legislative process goes, the board absolutely should discuss this bill at the very latest, the November meeting, because this bill, as a 2-year bill, would need to be moved out of its first house by January of next year. And you wouldn't have another meeting until February. So you could move on your motion to oppose unless amended, and then make sure to agendize discussion on this bill for the November meeting.
Yes, I think that's a good compromise. And actually, to encourage a fuller discussion, it would be nice to agendize it because I'd like to hear from people on both sides of the issue in the public.
I'll second that motion.
You already have a motion on the table, so.
Do we
yeah.
have second, right?
Yeah.
It's already.
Any other comment on that? A board comment? Public comment? Seeing no public comment. What? Oh, I'm sorry. Good morning, Guy.
Morning, Dr. Guy Atchison speaking as a private dentist. I just have to say that I oppose this mainly because of the lack of oversight and regulation. If this goes through, it's already been 7 years since you did an on-site visit. There is no other dental school in North America that has gone so long because they're under CODA supervision and are looked at a much closer time schedule. So if your job is to protect the public, it's not being done as far as examining that dental school in a timely manner, and you can't certify that. So that's my comment.
Thank you. Thank you. Any other public comment?
Hello, Tukas Okai from California Dental Association. I know there's been extensive discussion about this, especially at last year's meeting. But I did want to emphasize that one of the key pieces is that the board has shared that they do not have capacity to approve foreign dental schools. In fact, we're now looking at the challenges to approving dental assistant education programs and are looking at different pathways. Now, of course, they are separate issues, but the key piece is that the board does not have the bandwidth and capacity to be able to approve these foreign dental schools. And while there are, that we've heard about the challenges for CODA approval, we do have 2 foreign dental schools that have received CODA approval. So there is a process and a pathway to make that happen through through the appropriate entity. And it's just not the dental board. So that's what we've seen and why we recommend to oppose the bill language.
Thank you. Any other board comment? No, public comment, I'm sorry. Go ahead. And this is on the new motion that we're allowing him to speak. Yes.
Thank you, sir. Thank you, sir. So, Mr. President, what I was trying to suggest is.
Again, identify your.
Yes, sir. That instead of like foreign dental schools, this is just obviously a suggestion. If California is notorious, sorry for my language, for regulations and for like difficulty outside people from other states when they come to California to get license, particularly like dentists, nurses, and physicians. So if like a board can kindly look into other options of attracting dentists, like from other states, like on reciprocity. And also with, or like California used to have a bench testing and other like mechanisms before. So also, Mr. President, I know a personal example of a dentist from Maryland, active dentist. He's been trying to get into California to get a license for the last 2 years. And he's going through like the process. He is like experienced dentist and he had some like a disciplinary issue there 11, 12 years ago. And that issue, that allegation was dropped in federal court first, then in state court, then Dental Board of Maryland issued license. The person went through the process of probation, everything. And then it's so hard still, even after 2 years, the person is not able to get license. And the person is calling the board and there's no answer.
We're going to have to interrupt you because it's not appropriate to discuss cases before us. So we're going to have to stop. Thank you.
Thank you, sir.
Thank you. Any other public comment? Seeing none, the motion before us is to watch unless amended. Is that correct?
Oppose unless amended.
Oppose unless amended.
Oh, I thought it was changed to watch.
I think the motion that was up was.
Oppose, okay, I stand corrected.
Then we can go.
Yeah, we can.
Okay.
Next time.
Oppose unless amended.
Okay, the motion is opposed unless amended. Chan?
Chan, aye.
Chan, I. Chang?
Chang, aye.
Chang, I. David?
David, aye.
David, I. Felsenfeld?
Felsenfeld abstain.
Abstain. Felsenfeld. Forge?
Forge, aye.
Forge, I. Ladine, I. Medina?
Medina, I.
Medina, I. Olage?
Olagi, aye.
Olage, I. Thakur? I'm sorry, absent. You?
You abstain.
You abstain. Okay, motion passes.
Okay. Let's move on.
Thank you, Mr. Board President. Next bill is Assembly Bill 1307 regarding licensed dentist from Mexico pilot program. This bill would require the board to issue a 3-year non-renewable permit to practice dentistry to an applicant who meets specified criteria and require participants in the program to comply with specified requirements. The bill would authorize participants to be employed only at federally qualified health centers that meet specific conditions and impose requirements on those centers. The bill would also require an evaluation of the program to be commenced beginning 1 year after the program is started, prescribe the information to be included. The bill would require costs for the program to be fully paid for by funds provided by philanthropic foundations. The board would be required to process a new license type with an expected 30 applicants per year. Board staff determined there would be an increase in staffing and operational resources necessary to implement the bill. And such staffing and operational resources may not be available given the recent directives by the governor to reduce costs and eliminate vacant positions. And I just want to give kind of a brief background on what happened with the appropriations hearing and the costs that we estimated. The board, even though the bill states it would, philanthropic foundations would pay for it fully, the board would still anticipate time and resources to implement the bill. And so our concerns about implementation on the fiscal aspect pertain to the fact that the board estimates the cost of $334,000 in fiscal year 26-27, and then $318,000 for fiscal year 27-28, and then $159,000 annually ongoing to fund a new permanent AGPA position and a limited AGPA for research. And so we had conducted this. There's also the Office of the Office of Information Services that would need to set up a new license type, and that would cost an estimated $72,000. So the current version of the bill does not really address these fiscal concerns that the board has. The board has been working with the author to see if we can amend the bill to address these concerns. And so our recommended position is to oppose unless amended. Thank you.
Mr. Chair,
Yes, go ahead.
Robert David, I don't know why we wouldn't be support if amended on this one. If the fiscal issues that you raise are addressed, I think it'd be good to signal our support.
Go ahead, Ms. Welch.
Go ahead.
I have a few additional implementation concerns to raise. First, as the board has seen with the licensure by credential license pathway, at times, temporary licensees terminate their required employment before the end of their 2-year contract. In that event, the LBC license is revoked pursuant to the statutory requirements. However, under AB 1307, there is no provision to suspend or revoke the new 3-year program license upon the licensee's failure to maintain the terms of the program. Rather, an APA proceeding would have to be initiated, which could take years to complete beyond the 3-year term of the program license. The bill would require the board to issue the temporary license without the board first receiving individual taxpayer identification number or social security number, which conflicts with the provisions under BPC Section 30, applicable to all DCA boards that require the applicant to provide the ITIN or SSN at the time of license issuance, not after the license has been issued. A licensee failing to provide the ITIN or SSN shall be reported by the board to the Franchise Tax Board. The board may wish to request the requirements for the temporary license conform to the provisions under BPC Section 30. The bill would require applicants to complete an orientation program approved by the board, but the board has not approved any orientation program and is ill-equipped to do so. The bill would make the 3-year period of the license commence on the day the licensee begins practice, which will be difficult for board staff to track. The license should be effective on the date it is issued by the board. The board does not otherwise issue licenses with a future effective date. The bill also would require the program to be evaluated either by a California dental school or either the National Autonomous University of Mexico or any foreign dental school approved by the board. However, the board no longer approves foreign dental schools. It is also unclear how evaluation of the program by entities outside of California, especially foreign dental schools located in countries other than Mexico, would be beneficial to California patients. Alternatively, the bill would allow the evaluation to be conducted by an independent consultant selected by the Director of Consumer Affairs, which is not the statutory title of the Department of Consumer Affairs, and it is unclear how the Director of DCA would select an independent consultant to evaluate the program. The bill would require the cost for administering the program to be fully paid for by funds provided by philanthropic foundations. It is unclear how these funds would be paid or to whom. The board typically charges a licensing fee to cover staff costs to review the application, administer the license, and enforce the Dental Practice Act and supporting regulations. If staff time is necessary to create orientation program guidelines and review the orientation program for approval, that would be another cost. Aside from board costs, there may be costs associated with the provisions of the bill by the dental schools, California representatives, National Autonomous University of Mexico, and other entities named in the bill. It is unclear in the bill whether philanthropic foundations will pay the licensing fees and costs for all involved entities and whether the entities would submit invoices to the foundations for payment.
Thank you. Thank you. Thank you. Let's hear from any other board comments first. Go ahead, Dr. Lurie.
Irene here again. Again, this is a very sensitive topic, a lot of work, but the dental board's mission also has access, improve access to care in it. And we really have never invested in any access to care issues. We've just tried to look at dental assisting venues and improve dental assisting, improve staffing, but the access to care for patients has never been looked at and, again, invested. So there is a very good program in Massachusetts. I spoke about that, I think, one of our last meetings last year. That's been around for many, many years, and it's been very successful. It's the same program. So I would just think that we should also look at this in regards to access to care. And I wanted to ask you, what does referred to suspense file mean?
So any bill that reaches a certain amount of money in terms of taxpayer cost is automatically referred to the suspense file, is my understanding. And then they will, so the Appropriations Committee is very powerful. It's kind of the way that the Assembly, the Senate, get rid of bills without actually giving an actual answer. Unlike when I interact with my children and I say no, politicians don't like to say no to people. They like to have them die in committees. So very few bills die by way of vote. And so we will know suspense day, I believe, and please don't quote me on this. I believe it's the 22nd of May, so not too far away. And I just want to address, if I may, also, the board does value access to care, board staff do. And one of the concerns is just the implementation of this particular bill. And so the reason I think board staff recommend doing oppose unless amended is because we want to see if we can work with the bill author and the folks working on this bill to see if we can get it in a good spot. We don't know what's going to happen, but in its current form, the bill is, you heard the list that the board council read off. It's pretty hard to deal with as is. So we're hoping that we can work on it some more, and that's why we have the oppose unless amended recommendation.
Okay, thank you. And I believe there is going to be a dentist supervising over all the providers that will be coming from Mexico.
So
that's what my understanding. There's going to be a supervising licensed dentist.
So the federally qualified health center is a very interesting thing. It's this very sophisticated entity that my understanding is, yes, there's supervision. But, and that's good. But there's a lot of, as you know, there's a lot of factors in the implementation, and the fiscal too is extremely, it's only 30 applications. So it's like, well, why does 30 applications cost that much? What's going on? Is there something wrong with your calculator? The answer is just the way that the bill is written requires the board to do so many various things. It really isn't congruous with the way that the government entity operates, and it's not clear where this, you can say, okay, well, philanthropic money is going to come in and it's going to handle it all. It's not that simple. So we really have to, I think, take an oppose unless amended position and see if we can work and get this in a better space. But I don't know as to the question of the suspense file, what will happen. I don't know at this time.
Okay, I'm okay with oppose unless amended.
Thank you. Any other board comment? Let's go on to public comment.
Hello, Tukazokai California Dental Association, and we echo the board staff about allowing the executive committee to have some flexibility in the position, especially once the number of issues have been addressed in amendments and they're supposed to be inserted in appropriation, potentially remove opposition, but really just depends on, that flexibility being there. So I think that that's an appropriate position to move forward.
Thank you. Any other public comment? Seeing none, do we have a motion before us? Someone doing an amend position? I will do that. I will recommend a motion to oppose unless amended. Get a second?
You second.
You second. Any other board discussion? Any other public discussion? Seeing none. Madam Secretary. Oh, Tara, I'm sorry.
Is it public comment?
All right, so this bill is active. It is in the Appropriations Committee, so I would recommend just adding a couple lines to the motion, which is currently opposed unless amended, and then authorize the Executive Committee to work with the bill author to resolve the board's concerns. And if the bill is amended to resolve the concerns, authorize the Executive Committee to move the board's position to watch.
So accepted. So accepted. Dr. Yu? Yes. All right, I think we're ready for voting. Madam Secretary.
Okay, this is to oppose unless amended, 1307.
Thought I did. Okay.
Okay?
Well, let's ask for public comment because it was amended. The original motion was amended to authorize the Executive Committee to act on this. Okay, seeing none. Okay, now.
Okay, oppose AB 1307 unless amended, Chan?
Chan, aye.
Chan, I, Chang?
Chang, aye.
Chang, I, David?
David, aye.
David, I, Felsenfeld?
Felsenfeld, aye.
Felsenfeld, I, Forge?
Forge, aye.
Forge, I, Larin, I, Medina?
Medina, aye.
Medina, I, Olage?
Olagi, aye.
Olage, I, Thakur, absent, you?
You, aye.
You, I, motion passes.
Thank you. Mr. Nelson, thank you for that.
Thank you, Mr. Board President. The next bill is Assembly Bill 1434 regarding healthcare boards and workforce data collection. Existing law requires specified boards, including the Board of Registered Nursing and the Respiratory Care Board of California, to collect certain workforce data. We're just monitoring this in case the law changes to require the dental board to do something similar. Recommend position is watch. Thank you.
Okay, any board comments on this one? Seeing none. Public comment. Seeing none. Is there a motion for us to watch?
Question, Mr. Nelson, what is the bill number? And it's not in your list, I don't think, on our meeting materials. That's what my concern is. I don't know.
AB 1434, it's on
34,
page 209 of your meeting materials.
209. Oh,
Double
that's
check the
actual
index.
bill. We don't have it in the list here, is what you're telling. Okay. Thank you.
Okay, so do we have a motion to watch? Don't need to watch? Okay, I'm sorry.
You don't need a motion to watch.
Okay, got it. Okay,
Thank you.
sorry. Let's move on, Mr. Nelson.
Thank you, Mr. Board President. Next bill is Senate Bill 351 regarding health facilities. This bill prohibits hedge funds and private equity groups from being involved with a physician or dental practice doing business in California, making healthcare decisions or exercising power over specified actions, including decisions regarding coding, billing, and patient care services. The bill would also render unenforceable specified contracts between a physician or dental practice with private equity or hedge funds that include any clause barring any provider in that practice from competing with that practice in the event of termination or resignation. It also keeps them from comments regarding quality of care, utilization of care, or ethical challenges to the practice. Board enforcement staff estimate about 20 additional cases per year to investigate, which would potentially involve prohibited actions in connection with private equity or hedge fund ownership of dental practices. The recommended position is watch. Thank you.
Any board comment on this one? So just like we had before, watch, it just continues to watch. Seeing none, how about public comment? Seeing none, so the position is to watch. Continue.
Next bill, Senate Bill 470 regarding open meeting teleconferencing. The Bagley-Keene Open Meeting Act authorizes meetings through teleconference subject to specified requirements. Those provisions would be repealed on January 1st, 2026. And this bill would instead repeal those provisions in January 2030. This bill would allow the board to continue with the current process of allowing teleconferencing, providing cost savings and efficiencies for another 4 years. Recommended position is support. Thank you.
Thank you. Any board comment supporting the provision of teleconferencing? Seeing none, public comment. I'm sorry?
You motion to support.
You motion to support. Do we have a second on that?
I'll second. Chang second.
Chang second. Thank you. Public comment. Seeing none. I think we're ready for a vote.
SB 351, motion to support Chan,
Oh, no, 470. 470.
473?
470.
470. Motion to support 470 teleconference. Chan,
Chan, aye.
Chan, I, Cheng,
Chang, aye.
Cheng, I, David,
David abstain.
David abstain, Felsenfeld,
Felsfeld, aye.
I, Forge,
Forge, aye.
Forge, I, Larin, I, Medina,
Medina, aye.
Medina, I, Olage,
Malagi, aye.
Olage, I, 4 absent, you,
Aye.
you, I, motion passes.
Thank you. Thank you. Mr. Nelson.
Only 2 more to go. Here's Senate Bill 641 regarding state of emergency waivers and exemptions. This bill would authorize boards under the jurisdiction of the DCA to waive the application fees of certain provisions of the licensure requirement as specified that the board or DCA is charged with enforcing for licensees and applicants impacted by declared federal, state, or local emergencies. Board staff would need to coordinate with DCA to implement Breeze, which is our online payment system, such that the fee waivers could be facilitated. Board staff, due to the inability to predict the extent of future disasters, are not certain as to the extent of the fiscal impact of this bill and what it poses by allowing fee waivers, which it's a waiver, so it's revenue loss. It isn't like we're postponing the payment, we're waiving it. The recommended position on this one is watch. Thank you.
Position on 651 is watch. Any board comments? Seeing none. Public comment? Seeing none. So the position is watch. We don't have to act on it.
Next bill is SB 861 regarding the Committee on Business Professions and Economic Development Omnibus Bill. And an omnibus bill is basically where they make a whole bunch of cleanup changes to the law, non-substantive changes. This bill would amend various aspects of regulation and licensing across multiple boards and bureaus. The bill would reinstate BPC Section 16.5, which was repealed by the board's sunset bill that requires the Department of Consumer Affairs Director approval for the board to appoint its executive officer. This bill also includes the board's legislative proposal to conform BPC Section 1602 and 1603 subdivisions D and E to change the reference the former registered dental hygienist board member position to the new registered dental assistant position in accordance with the most recent amendments to BPC Section 1601.1. This bill reinstates the requirement for the DCA director to approve the board's candidates for executive officer prior to appointment. The board did not seek to reinstate this requirement, and it is unclear why this provision is being reinstated and why the director's oversight is necessary for the board to appoint an executive officer. Recommended position is support if the board agrees with the reinstatement of DCA director oversight over the board's selection of its executive officer. Thank you.
I don't understand this and I don't agree with it. I don't see why we need oversight for choosing the executive director by the DCA. It makes no sense to me.
It was unclear to us as well.
Any other board comment?
I have a question, Mr. Nelson. You said something about, we're looking at appointing an executive officer right now. And you said that the board would have, the DCA director would approve the candidate that we select Okay, I get that. I may or may not agree with it, but then, and also the applicants, is that what you said there? Somewhere in there?
The bill reinstates the requirement for the director to approve if the board's candidates for executive officer prior to appointment. So basically,
Is that plural or just the
Ca-
one candidate that
candidates.
we select?
oh, it's candidates, is my understanding.
Is that with an S, sir?
Go ahead, I'll let counsel, but
Once the board selects the executive officer, that selection, that one person is then submitted to the DCA director for the director's approval. So your decision to select your executive officer is subject to review by the DCA director under this bill. You're not alone. This was a prior requirement. I think it may have been inadvertently repealed under 1453. But recently, because of your transition with executive officers, DCA exec realized that the DCA director oversight of your candidate selection was repealed. So she's not approving your applicants, multiple. It's just whoever you finally select as for appointment, that person is then reviewed by the DCA director for approval.
That is what the gist of this bill would be relative to this board. That's a question.
yes,
Okay, thank you.
as Ms. Welsh described.
And
Thank
I
you.
will supplement that response with there are several other boards that also have this requirement, including the medical board. It may be, and I don't know, more of a stopgap when there are a large number of board members. Then the DCA director has to come in and review the candidate and then make that approval of the selection. So the dental board is not being singled out. There are multiple boards under the department that have this requirement.
Thank you. Oh, that's clear.
So I have a question. So if we oppose this, then does it mean the board solely has the ability to appoint the executive director?
If it passes.
Executive officer.
Under current law, the board's vote and selection controls. If you oppose, you would need to be very selective with that opposition. You would probably only oppose the addition of that section into the omnibus bill because there are other sections being added that we really need.
Okay, thank you.
I would move then an oppose unless amended position with just this specific issue about DCA approval of our hiring.
Can you speak
position.
closer to the mic?
Yeah, so I would recommend and move an oppose unless amended position. Thank you.
Do I get a second on that?
I'll second.
Okay, so to be clear, you're going to oppose unless amended to remove section BPC, section 1616.5 from the bill.
Correct.
All right. Any other board comment on the motion to oppose unless amended? Seeing none.
Yeah.
Dr. Chang. Any public comment on it? Good morning. Good morning, good morning.
Good morning, President Chan and board members. I just wanted to give a little.
Who are you?
Oh, Anthony Lum, Executive Officer of the Dental Hygiene Board. Sorry about that. I just wanted to give a little perspective in regards to my process when I became Executive Officer. And that was once my board went through the interview process with my board. We had a task force first for the eligible applicants. Then we had a formal interview before the entire board. And then they selected me as their Executive Officer. Subsequently, after that, then I went before the DCA director and deputy directors for an interview as well. They wanted to ensure that the board was going to have the appropriate person in place with the right mindset and the goals of the board in moving forward. So that was my experience in doing that, and I just wanted to give you all the perspective of it.
Thank you. Thank you. Any other public comment? Seeing none. I think we're ready for a vote.
Okay. Motion to oppose unless amended, 861. Ready, Bill?
Yes.
Removing 1616.5 from the bill. Chen,
Chan, I.
Chen, I, Chang,
Chang, I.
Chang, I, David,
David, I.
David, I, Felsenfeld,
Oh, no.
Felsenfeld, no. Ford,
Forge, aye.
Ford, I, Larin, I, Medina,
Medina, I.
Medina, I, Olage,
Olagi, aye.
Olage, I, Thakur, absent, you,
You know.
you know, okay. Motion passes.
All right, thank you.
That's all the bills that we needed to discuss, unless there are any other bills that you folks would like to go over or have questions on.
Thank you, Mr. Nelson. We
Actually,
got
I do have one question, Robert David. On this AB 350, which is related to fluoride treatments, making it a covered benefit,
51.
under the Medi-Cal program. I don't know why we wouldn't support that. It seems like that's good patient care, even though fiscally, I think it has very little chance of passing this session. But I think we should be on record as supporting fluoride treatments for the Medi-Cal population.
You want to talk about that?
Well, let me switch to it. So generally, the board staff did not really go into taking positions on things that do not directly impact the board. However, the board is, if you feel like AB 350, which would require healthcare service plan, contract, or health insurance policy renewed after January 1st, 2026 to provide coverage for fluoride varnish in the primary care setting for children under 21 years of age. I have to be neutral here. I like children, but I just don't, board staff don't usually make recommendations on bills like that, but you're welcome to discuss and make recommendations and we'll do what you guys think is appropriate.
Well, let's put this on the table. You want to make it as a motion?
Yeah, I'd move that we support AB 350.
Do we have a second on it?
I'll second that. Felsenfeld.
All right. Any other board comment on this?
Isn't this why we exist?
Yeah.
Prevent tooth decay? I mean, with all due respect to everything else we're looking at, don't we want our people to not have decay?
So, and if you would like, and please let us know if you'd like board staff to take a little bit more of a sense of that, and look at bills and make recommendations. But generally, my understanding and is that we don't make recommendations on things that are not directly impacting the board. But I see what you're saying. I certainly
Well, I
do.
understand that completely, but this is absolutely dental.
Yes,
It's
yes.
not, there's no spill out to any other boards that think, I think we need to support this. We'd look stupid not.
Any,
Oh, we're gonna hear from CDA about why we shouldn't do that, but okay.
let's ask for
Get
public
the
comment.
meeting.
Hello, CDA is a sponsor of this bill, and we would be very pleased to see that the dental board is, prioritizing disease prevention and the importance of fluoride varnish and accomplishing that. So if you move to support, we think that that's very aligned with the board's duties and goals.
Thank you. Thank you. Any other public comment?
What bill was it? 350.
Hi, Dr. Guy Atchison, private dentist. I want to speak for this just because it's, when you're talking about protection of the public, fluoride varnish is like a no-brainer and it's already approved for medical people to be able to apply it. And just reducing a barrier since 40% of the population is on Medicare, Medi-Cal. This is really a no-brainer to me. And I know you guys don't directly overlook it, but I think it's a good public statement. Thank you.
Thank you. Any other public comment? Seeing none, I think we're ready to vote.
Motion to support AB 30, Chan.
Does absolutely count as a yes?
A, yes. Chang,
Chang, I.
Chang, I, David,
David, I.
David, I, Felsenfeld,
Felsenfeld, yes.
Felsenfeld, I, Forge,
Forge, aye.
Forge, I, Larin, I, Medina,
Medina, I.
Medina, I, Olage,
Olagi, aye.
Olage, I, Thakur, absent, you,
You, I.
you, I, motion passes.
Thank you. Thank you.
And if there are any other bills that you'd like to discuss, again, I'll just remind you that I have to be neutral and focus on these, no matter how wonderful or terrible.
Thank you, thank you. And thank you for your work on preparing the background on this and the, all the other variables, not only now, but downstream, that we have to consider in making those decisions.
It's my pleasure.
So thank you for your work. And thank you for your, yeah, thank you. Thank you for the staff work on this too. All right. Where are we?
What's next?
We on the future agenda yet? Yep. Oh, my goodness. Okay, we are on agenda item 23, public comment on future agenda items on page 227 on the meeting materials. Do we have any discussion on the board first? Board members? Seeing none.
Well, yes, once again, I'm getting if it is public comment, I would like to just remind, Dr. Dougherty came in with something that really wasn't appropriate for him, he was putting it in, but we've asked him to drop that off, and I'd like that to be considered. That's all.
Thank you. Any other public comment? Seeing none. Oh, my goodness. We are on agenda item 24, adjournment. Thank you for attending, and thank you for the board members for working through all of our materials and the staff for preparing us to come here today. Thank you. Thank you. Oh, my goodness.